All right, Mr. Cavazos, your charge of failure to stopping of information, which is a Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you a 6-month deferred. Deferred is a type of probation that if you complete it successfully, you do not.
One mistake turns into many, and the courtroom keeps score. Warnings are given, mercy is shown, but patience is thin. In this room, confusion, excuses, and violence all collide fast.
Not end up with a conviction on your record. This is really important because, with these types of cases, if you plead guilty to it, they can turn around and sue you and use that against you.
Yes, sir.
And could cost you a pretty penny. Do you understand?
How does it get removed?
We'll talk about that.
So first, assuming you complete it successfully, you may be able to have it sealed. Okay? But first things first is you got to complete it successfully. If you fail to complete it successfully, you pick up a new case, you test positive for dope or alcohol, or you don't pay what you're supposed to, we're going to issue a warrant for your arrest. I'm going to put you in jail, and we're only going to talk about if you violated it or not. If you do, you're looking at up to 180 days in jail. Do you understand?
Yes.
I'll make you a deal. If you do well in half the time, you're nice to everybody, get all your classes done, you pay restitution, I'll take you off in half the time. You could be done in 3 months. That's no time. Get everything done quick and be nice. Pay the restitution and you're out.
Yes, sir.
How do you plead to the offense? Guilty or not guilty?
Guilty.
I will not find you guilty. I will withhold that for 6 months. So all you have to do is the restitution to a Miss Duran, an effective decision-making class, 12 hours of community service, no threatening, harassing, abusive contact with a Mr. Barrett. Do you understand?
Yes, sir.
Is this how you understand it?
Yes, Your Honor.
All right. We wish you the best of luck. All right. Get it done. Good morning, Mr. Washington. Where have you been?
Schedule, that's why.
You thought it was what?
Schedule, I got a text message that it was rescheduled somehow, but I guess it wasn't.
We give you a reset that tells you when to be here.
Yeah, November 11th, but then some on my phone it said the 21st or something like that, so it's just a miscommunication.
What am I supposed to do about that?
It wasn't my intentions. Thought it was today. That's why I came today.
Mr. Washington, I will give you a get out of jail free card today. It's not going to happen again. If the next time you don't come back, I will put you in jail and I'm not giving you another chance. Do you understand? I'm sending you now for a drug test because I want to know what, if anything, is in your system. You ever blow us off again, that's it. You will stay with me in custody. Do you understand? Take a seat for me. I'm in shock. You're on bond for DWI with us, and you've now picked up an aggravated assault with family. Do you mind, this is Mr. Drake Osby. What happened in the ag assault, please?
Yes, Your Honor. On April 1st, 2020, as first specified, the claim was the defendant are exes from a prior dating relationship. On April 1st, 2025, an officer was dispatched to an address in Houston County, Texas, responsible for disturbance call. The complainant stated there was a verbal altercation when the defendant took the complainant's cell phone. The defendant then entered the bedroom and began striking phone and objects to break it. The complainant was able to retrieve his cell phone, at which time the defendant began to strike the complainant in the head and torso with a close fist, causing him to fall on the ground. The complainant was able to walk away, and the defendant grabbed a metal object and struck the complainant in the head and arm, causing 2 lacerations on his left eye and a laceration on his right eye, and multiple scratches on both arms. The defendant then jumped a fence and fled the scene. The object was a solid metal bracket, 12 to 16 inches in width, made of heavy gauge steel designed to hold 2 cylindrical metal tubes and has multiple sharp forms. The item is manufactured for law enforcement officer use as a mounting or deployment device for entire inflation.
And all this over a phone? Mr. Drake Osby, I now have to revoke your bond in our case as well. I'm sorry, so I'm gonna set it at 5,001. You've still not made bond on the felony case, so if you do, I mean, we can talk, but John, I think he's set for when? She's set for,
514, Your Honor. Yes, sir.
okay, if you want to do, I guess, the day after then?
You look at one other thing, Judge. Well, I think the felony is actually set for Monday. Our case before this one was caught up was when she was reset for 514.
It's up to, I'm good with whatever you want to.
I'm actually looking, I don't have any new discovery to look over because this case is so new. There weren't even any body cams for me, so I'm pretty much waiting on everything. I'll leave it where it is and I'll monitor things and see what's going on with the felony case, Judge.
All right. Thanks.
Thank you, Judge.
So I've got a couple to talk to you about.
Okay.
Start with the easier one first. Mr. Ally, he,
Marquis Seller,
yes,
is he in prison?
no, he's on bond. He had a violation because apparently he was random drug tests.
Oh, right. Is he here?
He is here. He went and he's tested. He came back negative, which is positive. But I think there was a miscommunication or a misunderstanding about him having to go drug test. He's got a pretty extensive orange sheet. And he's doing a mental health PTI, which
Remember?
he's done the interview. We're just waiting on the report. So I think it may have just, when he missed the drug test, just a misunderstanding, miscommunication as to what the bond conditions were.
Edward Johnson?
Did you get the report on Ally yet?
Okay, I get those emails. I haven't gotten one, but I did speak
I've been
with.
waiting. It's been a long time.
Well, they do them in batches rather than piecemeal. And so we just,
I mean, he went and did it at least 60 days ago, no?
I don't think it's been 60, maybe 30, 45-ish, but he has gone. I did speak with the Harris Center and he,
I remember you telling me that he went.
yeah. We're just waiting, and the Harris Center, I know that they're very overwhelmed and understaffed and.
I get it. What do you want to do?
What, like I said, he's here, he's clean. If we
That's
could,
good.
yes,
Okay. I mean, he's clean, which is great.
Yeah.
All right, so let's set it, I don't know, maybe a week.
okay,
If it's not back in a week, I'm going to call it. I'll figure it
okay, perfect.
out. Who's
Let's do
next?
that. Mr. Jorge Pena, he's in custody. He has a fugitive case,
He's a what case?
a fugitive case.
Okay, oh, hi,
And,
Amy.
he would like to speak to you about getting a new lawyer.
About a bond?
No, he wants a new court-appointed lawyer. And
Do you mind bringing out Jorge Pena, please? Pena, please.
I don't want to presume to speak for the court,
Is it
but
upset with you?
apparently,
I find that really hard to believe, really.
Judge,
And you go to bat, so I don't get it, right?
this is the first time.
He thinks he can get a different result. Is it just because of the fugitive case?
So he has a fugitive case and a local case, which makes it a little more complicated.
He's made bond on the local case, which is good. So the 15 days, did he waive or did he refuse? Okay. He looks young. Huh?
The court offers chances, but only once. Miss deadlines, break rules, or let anger take over, and the system snaps shut. In this courtroom, accountability decides who walks free and who doesn't.